Good morning, Your Honor. Jennifer Dusman-Coy on behalf of Kayla Cotton.
Good morning, Your Honor. Katie Komorowski on behalf of Ty Cotton.
Thank you. And Ms. Komorowski, this is your objection to a child support recommendation, is that correct?
Yes, Your Honor.
All right. And what are the objections?
The objections are that in July of 2023, the parties had a mediated agreement. That mediated agreement stated that Ty's disability payments will be retained by him in full. This calculation includes the disability payments as being part of the calculation for part of his income, and I believe that is incorrect. It should not be considered as part of his income because the parties had deviated from the standard calculation under MCL 552.605 and 552.6053 by making this mediated agreement to provide that Ty's disability payments would be retained by him. Also, this agreement provides that the defendant is needing to be paying the plaintiff premium payments, and that is incorrect. The defendant pays the cost of TRICARE directly. The premium adjustment in the calculation is incorrect. Also, there needs to be an adjustment as far as the ordinary medical calculation and how much each party is responsible to pay as a percentage. Each party had previously agreed last year that each person would be paying 50% of any medical or dental expenses, and the percentages are different in this calculation. The other factor that I would ask the court to please consider is that the mediated agreement said that we would go and we would have the military retirement pay discussed in front of the court, which we did do. And the judge did decide, Judge Mertz decided that the retirement pay would be divided by 35%. Meanwhile, as part of the mediated agreement, there's also a separate retirement account that the defendant has, which is a thrift savings plan account through the military. And as part of his agreement to keep his entire disability pay, the defendant willingly gave 50% of his TSP to the plaintiff. And I believe that had he not done that and given that up at the mediated agreement, that the plaintiff would have only ended up with 35% of that as well. So she ended up with an extra 15% of his TSP than she would have had otherwise in making that agreement. And when this divorce is finalized, the plaintiff will have 35% of the total of the defendant's military retirement pay as part of her income, and the defendant will have 35% less of his military retirement pay as part of his income, which will put him in a very different financial situation as far as total income and as well as her. She will end up making, I believe, more money overall than he is making. Because this has gone on and on and on, and this is more than 2 years now that this divorce has been going on, the defendant did need to obtain a part-time job, which he had submitted the paperwork for that to the court, and that is in the calculation so that he can afford to pay attorney fees and court costs and continue to go to court. So the defendant really cannot afford this, and it's very grossly unfair for us to have to keep coming back to court to argue about what we agreed upon 2 years ago. And I would just ask the court to please consider all of those factors with this objection.
Okay. So there is no judgment of divorce yet.
No, there is not. We have prepared one. The parties both signed the judgment of divorce last year, a year ago in June. And unfortunately, the plaintiff's attorney did not return that copy that was signed to me until September. And when I filed to request that Judge Mertz enter that on a motion, he did not enter it because we were in the middle of a custody motion, and that has been resolved. And now all we're talking about is child support. And the judgment of divorce still has not been entered.
Ever been any support orders that entered in this case? No?
There was a support order originally entered that the parties originally opted out of the front of the court services in June of 23. There was a recommendation made and an order made that no one objected to. That particular recommendation did not include Mr. Cotton's disability pay. And that particular recommendation had the plaintiff paying Mr. Cotton a small amount of money, which she never did pay. And, Mr. Cotton did not necessarily object to it. He was not necessarily looking for her to be paying him money. They had made an agreement on custody to be 50-50 and essentially to opt out of services. And then we opted back into services. She has never been made to pay what she was supposed to pay. He's never been given credit for what she was supposed to pay. And then now we have this other calculation that's including his disability pay. And again, I believe that's incorrect.
All right, Ms. Dukes-McCoy, what would you like to say to each of those objections?
Thank you, Your Honor. I had filed a response. I'm not sure if the court had gotten it yet. For some reason, we have ridiculously slow mail. But anyway, first I want to address Ms. Komorowski's characterization of this case. The parties had all signed an agreement in June of 2024 that would have, and we would have had the judgment of divorce entered then, but there was a problem with the minor child and the parenting time with him and his father. We filed a motion in July of 2024 that was heard eventually by Judge Mertz. That was before this court, and then it went before Judge Mertz. We finally got that finalized back in March, and then we had an objection that was made to the child support recommendation. The parties had opted out in front of the court services. There was an informational child support recommendation that was made at that time. No party was ordered to pay support, and so there has not been an actual order in this case regarding support. So I just wanted to make those clarifications. The divorce is set to be finalized, and it would have been finalized but for the objection to the child support that we're here on today. We did not agree that the disability payments would not be included in child support. That was part of the property division for the parties. And I think it's disingenuous for the defendant to come before the court and say, I gave her property, meaning the plaintiff, so I don't have to pay support. That's not the way it works. If Mr. Cotton has a genuine change in income after we get the judgment of divorce entered, after it enters, and my client starts receiving military retirement pay, if it's a significant enough change in income, he can request a change in child support. And so I think that objection is not appropriate at this point. So again, as to his military pay and the VA pay that he receives, that's income that's included under the Michigan child support formula, and there's no reason not to include that. The premium adjustment is correct. The ordinary medical percentage is correct based on the party's income. And so I think that this is a frivolous objection just because Mr. Cotton did not like the amount of support that was recommended. So we would ask that the court deny the objections.
As to the statement that the parties agreed to do 50-50 for uninsured expenses, is that accurate or not accurate? That
was at the time that we had, firstly, the parties had made an agreement in 2023 before they had gone to mediation, actually, in this matter, to the equal custody and parenting time of the minor child. But that changed because we had filed that motion back in July of last year. So that is not the circumstance any longer, and so that would not be appropriate to enter at this point.
Okay. Is your client paying any health care premiums, or is it just Mr. Cotton that's providing it for the child?
I believe it's Mr. Cotton.
Okay. In front of the court, do you know offhand if that was calculated with Mr. Cotton or Ms. Cotton?
It was calculated for him to carry insurance and to incur costs, but I do believe that there's still state assistance for the plaintiff for medical.
That is correct.
Connor, I
But you
don't
had
believe
his-
that it's appropriate for the child to be receiving TRICARE and Medicaid at the same time. And the child is not going to lose the TRICARE insurance when the divorce is entered either. Mr. Cotton should not be liable to pay for Mrs. Cotton's Medicaid insurance as a premium adjustment.
Your Honor, the calculation did include the cost of his medical insurance.
Okay.
And the child on the case, and actually included in that is parent or the plaintiff's coverage as well in that cost.
So she got a credit for what she pays?
No, the calculation input based on the amount that we had put in, indicating that the plaintiff is also covered by that. I would have to look at the calculation in order to see if there was a credit given, but it was based on the calculation of inputting the information.
Ms. Dukes McCoy, anything else you want to say on that healthcare premium issue?
The healthcare allocations appear to me to be correct, Your Honor, under the current circumstances of the parties. And it looks like there was a minor offset on that amount, and I think that's appropriate under the circumstances.
Right, anything else you wish to say, Ms. Komorowski?
Yes, Your Honor, I do. Mr. Cotton would not have made this mediated agreement with the wording that we included if that disability pay was going to be included in the calculation for child support. And if this ends up being included, then I will have to make a separate motion to have that entire mediated agreement set aside, because that is not what his intent was behind making this agreement. Whether or not Ms. Dukes McCoy feels that it's disingenuous or not, it is not. That was not the intent at the time that that was signed and created. Also, I just want to express that I disagree with the medical amounts in that calculation. Sounds like the front of the court mentioned that it appears that calculation may include a credit for Medicaid for Ms. Cotton's coverage, which I would argue is not appropriate. And again, I do not believe that the minor child should be receiving Medicaid and TRICARE. I believe that if the child's receiving TRICARE, he should not be receiving Medicaid. Everything is covered under TRICARE. There's no need for him to be on Medicaid. And quite frankly, while the parties are married, Ms. Cotton has been on TRICARE. There's no reason for her to be on Medicaid until the divorce is finalized.
Your Honor.
Yes.
For additional clarification on the healthcare coverage, reviewing my notes, the plaintiff does have dental and vision through her employer, so that offset amount there is calculated based on her paying $34.03 bi-weekly on that. There's not a credit for her to be carried under his insurance. That amount is because she's paying for types of insurance for herself.
May I ask a
Well,
question?
I was hoping to avoid is an evidentiary hearing because we can't have one until August. I think this case is setting a record for the most files with the least amount of progress already. But it looks like maybe we're not going to get to the point where I can make a decision today. I'm only hung up on the healthcare really at this point, though. As to the disability pay, as in the mediation agreement, it says the payments will be retained by him in full. It doesn't say that it would not be calculated as part of his income for child support purposes. I mean, I would read that as he's getting the full payment and that Ms. Cotton is not getting any payment. So I'm gonna go, I'll just go line
Your
by
Honor.
line. So that particular objection, I am going to deny. It is considered income, and it is considered income for purposes of a child support calculation. I don't see that mediation agreement indicating that it would not be used as income for a child support calculation, simply that he is getting the full receipt of that, and that is not a asset that's being divided up as part of the divorce. I will ask that front of the court review the healthcare costs and payments, and we may. So I'll grant an objection as to that. We review that to make sure we have that appropriately calculated and have all the important information that we need as part of that calculation. So we will issue potentially, we'll issue a new recommendation. It may be the exact same amount, it may be different, but we're going to take another look at the healthcare issue. Obviously, this makes it difficult if the parties aren't divorced yet, because then there might raise some new issues when health insurance changes. The retirement pay adjustment, again, that's something that hasn't happened yet. So when the divorce is filed, suddenly Miss Cotton's income goes up and Mr. Cotton's income goes down, then it would be appropriate to make a new calculation. So the objection is denied in part, granted in part, and the front of the court will review the healthcare matter and issue a new recommendation. Any questions, counsel?
No, thank you.
All right, thank you for appearing. We will get that new recommendation prepared and out to the parties. Thank you.